The topic is the Constitution and the Civil War amendments, Amendments 13, 14, and 15. And the guest is Dr. Blackshear, who has given us some information relative to the Constitution as well as the 13th Amendment to the Constitution. And of course, Dr. Blackshear, let's have you to continue your discussion in reference to these three amendments.
Well, before the break, I was trying to emphasize the point that the 13th Amendment that abolishes slavery abolishes the characteristics of being a slave as well. And one of the characteristics of a slave is lacking the ability to make or engage in contracts on the same terms available to all citizens of this country. So the 13th Amendment abolishes. So if black people are prevented from entering into negotiations with various racially exclusive emissions policies of white businesses and so forth, they are still, that's violation of the 13th Amendment.
That denies the right to make contracts.
Right, it denies them the right to make contracts, which means that they're not really free, because that's the characteristic of a freeman. And the specific statute that you would file a lawsuit on to prevent such a conduct would be Title 42, United States Code, Section 1981, which is frequently used in employment discrimination cases. Now, the 14th Amendment, if you listen to the wording when it says, no state shall deprive a person of life, liberty, or property without due process of law, or deny unto them equal protection of the laws, it is saying, for our purposes today, that the government cannot engage in private discriminatory conduct. But it's also saying the government cannot even get involved in it. So, but before the 14th Amendment becomes applicable, there must be, as we call it, some state action, some state involvement, some state connection with the private activity in order for the 14th Amendment to apply to prohibit it. So we come up with three approaches to make sure that that occurs. The most common approach used is the agency approach. In the old case of Shelley versus Kramer is a good example of the racially exclusive racially restrictive covenants, where you have these deeds that would say that you can't sell this property to members of African ancestry. Well, in Shelley versus Kramer, a person violated that deed and made an attempt to sell the property. Well, the government, through its third branch of government, which is the government of Missouri, through its third branch, which is the court, enforced that deed because it is a contract. But enforcing that deed, the government got involved in discriminatory conduct. And once that happened, the 14th Amendment now becomes applicable, and it prohibited the whole thing. So you can have racially restricted covenants and deeds all over the place, but there's no court that can enforce it, because then the government, through the courts, will be involved in that discriminatory conduct. And so now we have satisfied the requirement of state action, state involvement, sufficient for the 14th Amendment to apply and prohibit it. The other approach is the encouragement approach. The old case of Reitman versus Mulkey in 1968, where you go through an initiative referendum to amend your constitutions in California. You had this person that submitted a petition to amend the Constitution by forbidding